Well, why don't we get started? I'm John Grotasnda. I'm the Dean of Villanova Law School in Pennsylvania, and I'm also a member of the Advisory Council of the CISG. I want to welcome you to our last panel for the day. I want to thank you for coming and thank the organizers for having us here, and also thanking our sponsor, the New Zealand Law Foundation, for making this all possible. Our panel today is on a wide variety of topics, all involving international contract and interest issues, ranging from e-commerce to the interplay between tort and contract law and the awarding of interest. And we have three very distinguished panelists to address you today. Professor Dr. Yesim Atamer, who is a professor of Istanbul Bilgi University, Professor Sieg, Eiselen, who is a professor of private law at the University of South Africa, and Professor Hiroo Sono, who is a professor of law at Hokkaido University. And so we will begin today with Professor Atamer, who will talk about interest.
Thank you very much, John. Oops, I think this is not quite suitable for a class. Yeah. Ladies and gentlemen, it is really a pleasure and an honor to be here with you here in New Zealand, and thank you to the organizers for this wonderful conference and also to our sponsors. Now, as Professor Grotasnda already told, my topic is going to be on the interest claim. That means substantive law, the CISG. Why the interest claim? Because interest is one of the major issues debated under this convention. Even though there is an interest claim granted in Article 78, we will see it, the major details of this claim are left open. For example, the interest rate is left open, when interest starts to accrue, when it stops to accrue. So I will try to give you an overview about the different solutions offered in the doctrine and also which one I would suggest. But first of all, maybe why interest is granted when we pay late. This question might lead us later also to the answers. Now, as you see, it's already under Roman law, that means 2000 years earlier, that the rule is he that delays to pay what is due pays less than is due. That means there is a loss which then should be compensated, and that's the idea of interest, and this rule is accepted in most of the jurisdictions today all over the world. Now, when we look into the predecessor of the CISG, into the Convention of 1964 on, again, the sales, we see that there the question was not left open. At that time, probably the discussion was not that fierce as it was when drafting the CISG. And here we find answers to most of the questions, and the most important one, we find also the answer for the rate of interest. That is, the rate applicable in the country where the seller has his place of business. That means he delivers the goods and he is going to get the purchase price, so we look at the place of the seller. Now, if we look at the Article 78 in the CISG, we just see a statement, nothing more, and it tells us the party who has not got a sum paid on time is entitled to interest. That's it. It is not anymore only the purchase price, so it's broader in scope in that sense, any sum that is in arrears, but it just says is entitled to interest. That means we have a lacuna in the CISG which has to be filled. Now, let's try to find first the prerequisites for an interest claim to be given under this convention. First of all, there must be a non-payment. Non-payment regarding any sum would trigger interest to accrue. That might be a purchase price, that might be expenses. Any loss, any damages claim will trigger interest to start to accrue, or a contractual penalty I had to pay because, for example, late delivery. That all of those are sums which are not paid on time and which will trigger then interest. Now, which is very important to stress, what we have under some jurisdictions but not under the CISG, the sum does not need to be liquidated. That means even though I don't exactly know what type or what amount of loss the other party has encountered, I still must pay interest, even though it is not liquidated. And here we see also in the CISG case law that there is sometimes a different application, that the courts rule, for example, that from the moment judgment is given or from the moment the case has started, proceedings have started, that from that moment onwards interest is calculated. But this is absolutely not the idea Article 78 is written for. Now, prerequisites to: it must be a sum which is due, which is mature. So to become in arrears, the sum must mature. For the purchase price, it is obvious. We can look into the contract. It might be defined by the parties. It will often be so. If not, we have a residuary rule, a default rule under Article 58 of the CISG, which tells us that the rule is always concurrent performance. That means the moment when delivery is fulfilled, then I must also pay. Whenever I hand over the documents controlling the disposition of the goods, payment must be done. Now here again we see that now and then courts decide wrongly in that regard, and Article 58 should always be kept in mind, which is very important for the interest to start accrue. From that moment where I did not pay, interest on the purchase price will start accruing. Regarding damages, as I said, they don't need to be liquidated. That means the moment the loss was encountered is decisive. The moment I paid the penalty to a third party will be the moment when interest starts accruing on this amount. The moment, for example, I have made a covered transaction, that means because the buyer did not accept the goods or the seller did not deliver on time, I had to make a covered transaction. From that moment onwards, again, interest starts accruing. Or it might be an anticipatory breach, which is accepted by the CISG, and I avoid earlier in time, when normally the price would be due, still interest would start accrue from the moment of avoidance. For any expenses, obviously, again, the time, the moment they were made, interest starts accruing. No other prerequisites than these are asked for. Again, many civil law jurisdictions ask for an admonition, for a notice or reminder to put the other party in default. This is not the idea of the CISG. No reminder is needed. For an interest claim, we don't need to prove any actual loss. Even though I might have not made use of this money at all, I mustn't prove anything. I will have the right to ask for interest, but this is probably similar in most of the jurisdictions. And we have a strict liability for the interest claim, which means, obviously, under the CISG, we have a strict liability in general for all the claims, but there is a force majeure excuse, an exemption given in Article 79. But this type of exemption would not apply for an interest claim. That means even though there was a United Nations embargo and I was not able to transfer the money, even though I wanted it, I was not able to do it, it's a force majeure case, still interest would accrue, because the idea is keeping that money makes me richer, I can make use of that money, and the other party is losing the interest on that money. The calculation of the interest rate. Probably this is the most debated issue. If we have a contractual rate, no problem. Then the problem is solved. It can be a usage between the parties also. But what if the parties have not provided for an interest rate? Now here the problem is that we must fill in the blanks in Article 78. Now this convention tells us when there is a lacuna in the convention, we have two options. Either we try to find the solution, we try to deduce a solution from the general principles of this convention, in conformity with the general principles of this convention. That means we don't look into any national law at all, we find the solution from within the convention. Or, in the absence of such principles, the second option is we go to the applicable law. Now, a convention which tries to uniform law obviously doesn't want this last resort rule that we go to the applicable law. So it must always be the aim to find at least something from within the general principles of this convention. And the idea is obviously whether or not we can find an interest rate in this convention, even though Article 78 doesn't say anything. We have here two major streams in case law. You see, for the uniform approach, there are really very different uniform approaches. So most of them say that the interest rate at the place of business of the creditor should be applied. Debtor's place of business, it's another solution offered. Current interest rate related to the particular currency, or an internationally accepted rate like the LIBOR, which is probably not anymore that reliable, I think, or the Euribor, or, for example, rates which are given in international soft law rules like the UNIDROIT principles on international commercial contracts. Other courts are just applying domestic law. That means they say there isn't any general principle deducible from this convention. We can't do anything else than ultima ratio, last resort, to go to the applicable national law. Now, if we look into the case law with figures, we see in 245 cases that at the end, be it via the private international law rules or directly, in 104 cases, the creditor's place of business, the rate applicable at the creditor's place of business, has been the one applied. That means in the vast majority, we find that the creditor's place of business is really decisive. Debtors is 18. No explicit rule applied is also very often 48 cases. That means that the court just said 6% interest rate without even explaining where this 6% is derived from. Now, looking also into these cases, my proposal would be that definitely a uniform approach should be preferable. That means that we should find a solution from within this convention. And this is also very important because we need predictability in international sales. In international contracts, this is really one of the most important issues. And if you see, for example, here these solutions show us that there isn't any predictability for the time being in case law. Now, I would say that the reasoning, that the general principles where we can base our solution on is, first of all, the idea of compensating loss. Interest here is based on the idea of compensating loss, not disgorgement. It is a very special damages claim, though, because you don't need to prove your loss, and no exemption is possible, so it's really very radical for the side of the debtor. And this special regime of interest that you can claim without proving and without exemption possibility for the debtor should be applied really only in an amount which you would for certain also get in a national sales law. That would, for me, lead us all the time to the creditor's place of business. That means the creditor would normally make use of that money he is lacking at his own place of business. And that interest rate he would normally also get when he would conclude a national sales contract. So in that regard, I would suggest a rule to read this rule into Article 78, that we calculate interest according to the law of the state where the creditor has his place of business. In fact, that seems to be also private international law provision, because we are showing to the law applicable, the creditor's law, but as you see, it's going to be in every case the same law applicable. The creditor's state will define the interest rate applicable. And in this country, there might be a statutory interest rate. That means we might have laws where it is said if there isn't any contractual provision, then this and that interest rate will apply. Or the interest rate is applicable, we can find from case law also. So I think that will help for improving the predictability, and it will also go in line with most of the cases decided until now under the CISG. Whether or not compound interest can be awarded is also very much debatable. And I think the same solution can be applied also here. That would mean that we wouldn't say the CISG will allow for compound interest or not. We leave it again for the law applicable in the creditor's country. That means the creditor state, if that accepts compound interest to be calculated, be it in 3 months or 1 year time, then compound interest can also be asked for, but otherwise not. So again, Article 78 will not give an interest rate like 8% will apply. That would be reading too much into this convention, but at least Article 78 will always lead us to the same country, the country of the creditor. How is payment of interest affected? It must be obviously in the same currency as the principal sum. That's, I think, no debate. At the same place of payment as the principal sum, also no debate, and same payment formalities should be kept as the principal sum due. So it will always, as an accessory to the principal sum, it will always follow this claim. Would there be any defenses against an interest claim? We said any force majeure defense is not given. Any force majeure defense is not given. But still, there are at least two we could make use of. If I can transfer the money due to a failure on the creditor's side, then the creditor should not be able to ask for interest later. That means if he or she didn't give me the account number and I wasn't able to pay on time, that's regulated for under Article 80. I should not be able to ask then as the creditor for interest. And the second one would be, again, regulated in general, obviously, not just for the interest rate, in Article 71, that I might have a right to suspend performance. That means, in our case, to suspend payment, because the other party is not performing. I'm also not performing and not paying in this case. So in these two cases, there wouldn't any interest start accruing. When does the interest claim end? This is in principle also very easy, but it seems very easy. The interest ceases to accrue when the obligation to pay is extinguished. That means normally the normal case would be I pay the money and the interest and it's all over. And money, a sum due which is paid, would not go on accruing any interest. But here the discussion will also come into play whether or not this is a pre-judgment or post-judgment interest rate. In civil law countries, we mostly don't know a post-judgment interest rate. It is the pre-judgment interest rate which is really calculated up until the final moment of payment. But in any country where there should be a post-judgment interest, there obviously the CISG solution will only be applicable until the award is rendered and final. And from that moment onwards, it is in a way a new obligation which starts then accruing the post-judgment interest rate. The relation of interest to any additional damages. This is also very expressly regulated in Article 78. The Convention tells us the interest claim is a minimum claim you can ask for always, but if you have additional losses encountered, additional losses, obviously you can always ask for them under Article 74, which is the general norm for a loss claim, for a damages claim. For example, what we have also in case law, if you have taken a bank loan because of the lacking money and the interest rate was higher than the applicable residual interest rate in the creditor's country, then you might ask for the interest rate of this bank loan. But the damages claim is always subject to Article 79. That means the force majeure limitation is given here. I think this was also my last slide. Thank you very much for your attention.
Thank you very much. Next, we have Professor Sono, who will talk about the function of Article 5 of the CISG, reconsidering the boundaries of contract and tort.
Thank you, John, and good afternoon, ladies and gentlemen. I'd like to thank the organizers of this conference, AMINS, and also the New Zealand Law Foundation for making it possible for us to fly to New Zealand and to participate in this conference and to hold this panel. My topic is the function of Article 5 CISG. However, before I go into Article 5, I would like to begin with an overview of the relationship between the applicability of the CISG and domestic law. This relationship is sometimes misunderstood. Well, first of all, the applicability of the CISG is decided in accordance with Article 1 of the CISG. And this is independent of private international law rules. This is an autonomous application of the CISG. If you have the text with you, Article 1.1a says that the CISG will be applied if the contract is international sale of goods and if the parties have places of business in different states and if those states are contracting states. Article 1.1b says that the CISG will apply when the rules of private international law lead to the application of the law of a contracting state. This is a complicated provision, and since the private international law is referred to in that provision, it is sometimes misunderstood that the CISG is applied as a result of the application of the private international law. However, that is not the case. The CISG is applied not as a result of the private international law, it is applied as a result of 1.1b, which says that the convention must apply, not the law that is applicable according to the private international law, but if the private international law says leads to the application of contracting state law, then instead of applying that contracting state law, it is the CISG that should be applied. Now, that is for the applicability of the CISG, and that is a public law, public international law obligation of the contracting states to apply the CISG when Article 1 directs the contracting state or the forum to do so. That does not touch upon the other route of choosing the applicable law. That is, in other words, the rules of private international law are not excluded either by the CISG. What I said with respect to Article 1 only speaks about the applicability of the CISG. It does not say anything about the function of private international law. And so even in cases where the CISG applies, the applicable domestic law will still be decided. And as a result, there will be two layers of applicable rules, the CISG and the applicable domestic law. And why must such applicable domestic law be decided even if we know that the CISG applies? This is because the CISG governs only two aspects of international sales. Yes, right here. The first one is the formation of the international sale of goods, or the contract for the international sale of goods. The second aspect is the rights and obligations of the seller and buyer arising from those international sale of goods. These two are matters that are covered by the CISG. Matters not governed by the CISG includes questions of validity of the contract or the proprietary effects of the contract, and the limitation period or statute of limitations. It is not covered by the CISG, and also the liability for death or personal injury. The seller's liability for death or personal injury is not covered by the CISG. And this last part is the topic of, is the focus of my presentation. However, before I go into Article 5, I have one more slide. What is the applicable law for matters not governed by the CISG? And what is the law applicable for matters governed by the CISG? For matters not governed by the CISG, it is the applicable domestic law. That becomes applicable according to the private international law rules of the forum. For matters governed by the CISG, it is the provisions of the CISG. If there is no provision of the CISG or no explicit provision of the CISG, then we have to look into the general principles of the CISG. And if there is no general principles of the CISG, it is then when the applicable domestic law comes in again. So this is the hierarchy of norms that is within the CISG system. This is the hierarchy of norms, and this is in accordance with Article 7, Paragraph 2 of the CISG. But I left out one thing, that is a parties' agreement. Parties' agreement always takes precedence over all of these set of hierarchy, all of these norms, and that is in accordance with Article 6 of the CISG. Now that's the only slide that I have an animation on it. Okay. Now I move on to Article, now I turn to Article 5 of the CISG, and I would like to proceed with what I said before in mind. Now, if the seller delivers non-conforming goods to the buyer, and the buyer, sorry, if the seller delivers non-conforming goods to the buyer is given remedies listed under Article 45 of the CISG. And among them, the buyer is allowed to claim damages. The amount of damages is determined in accordance with Article 74, which sets forth the principle of full compensation subject to the limitation of foreseeability. That's the first two lines. And however, Article 5 provides a carve-out of for seller's liability for death or personal injury caused by non-conforming goods. Article 5 provides that this convention does not apply to the liability of the seller for death or personal injury caused by the goods to the buyer or any other person. For such loss, the governing law is the applicable domestic law, not the CISG. The policy or purpose of Article 5 is expressed in the legislative history. Article 5 is a provision that was added at the very last moment of the drafting of the CISG. It was added at the 1980 United Nations Diplomatic Conference, which gave birth to the CISG. And therefore, the drafting of Article 5 may not have gone through the rigorous deliberations of the working group meetings during the 1970s, which culminated into the 1978 UNSTROL draft. The addition of Article 5 to the CISG is a result of proposals made by Finland, France, and the United States. The purpose of the joint proposal was to accommodate domestic legal rules designed to protect victims of defective products, namely product liability rules in particular. The understanding at the diplomatic conference was that without Article 5, what would happen without Article 5 was that different results with respect to applicable law will arise depending upon the legal characterization of product liability laws under domestic laws. It was considered that under domestic law, which characterizes product liability law as tort law, here, and which allows concurrence of claims, which I call cumulative rules, the buyer will, in addition to the protection by the CISG, be able to resort to domestic product liability law, contract law CISG, tort law, PL law, or domestic PL law. While on the other hand, jurisdictions that characterize product liability law as contract law, contract liability. In those days, in the early 1980s, France was one of such examples. For those jurisdictions, that characterize product liability as contract liability, or jurisdictions that use non-cumulative rule that do not allow concurrence of claims. For those jurisdictions, the CISG will take precedence over domestic PL law. So this result, the difference of these between this jurisdiction and these other three jurisdictions. This was something that was considered necessary to be fixed, because this will result in a situation where some jurisdictions will be stripped of their domestic products liability law, while other jurisdictions will still be able to resort to their domestic products liability law. And Article 5, now what happens with Article 5? Article 5 was intended to ensure that in every jurisdiction, matters relating to the seller's liability for personal injury arising out of non-conforming goods are governed by domestic law, domestic products liability law, and not the CISG. In other words, the intention was to give priority to domestic rules of the product liability. However, the underlying assumption in the reasoning that I just gave is quite questionable. The underlying assumption in the discussion during the drafting of the Article 5 relies on the domestic characterization of claims. That is, the assumption is that the CISG preempts domestic contract law claims, but that it does not preempt domestic tort law claims. This is a questionable assumption, both from the viewpoint of the purpose of the CISG and the design of the CISG. This is counter to the goal of the uniformity, since it gives discretion to each jurisdiction to decide which domestic law claims will remain intact even when the CISG is applied. And uniformity will be better served by an interpretation that does not rely on domestic characterizations, but by an interpretation that focuses rather on the scope of the CISG. And the underlying assumption is also counter to the design of the CISG. In principle, the CISG preempts the application of domestic law with respect to matters already governed by the CISG. That is the hierarchy of norms that I showed you in the earlier, one of the earlier slides. Thus, the better view is that characterization of claims under domestic law is irrelevant, and whether a claim for liability is characterized as contractual or non-contractual, extra-contractual, or tortious. Under domestic law, if the claim is for liability for the seller for death or personal injury, that claim is excluded. Now, this begs the question of then what actually the policy of Article 5 is. What policy does Article 5 actually entertain? The practical consequence of applying the CISG to buyer's remedies is that the buyer will be subject to the requirements imposed by the CISG in requesting remedies. Most notably, Articles 38 and 39, and I have this slide, which is a copy of Article 39. Article 39 bars the buyer from bringing damages claims, not only damages claims, but any remedy, claims of remedy, when notice of the defect or nonconformity of the goods is not given within a reasonable time. So, paragraph 1 says the buyer loses a right to rely on the lack of conformity of the goods if he does not give notice to the seller specifying the nature of the lack of conformity within a reasonable time he has discovered it or ought to have discovered it. Moreover, paragraph 2 is even more harsh. In any event, so in any event, meaning even if the buyer has not discovered the non-conformity, the buyer loses the right to rely on the lack of conformity of the goods if he does not give the seller notice thereof at the latest within a period of 2 years from the date on which the goods were actually handed over to the buyer. So there is an absolute 2 years cut-off period under the CISG. And accidents can happen 2 years after handing over of the goods. So these time limitations, so these time limitations are the problem that are the practical problem that arises when one says that the CISG applies to non-conformity of goods. And if there was no Article 39 in the CISG, there would not be much problem saying that CISG excludes all tort law remedies. It is because of this article that it becomes problematic that the CISG would exclude domestic tort law claims. These time limitations may be appropriate for protection of contractual interest or commercial interest, but may be inappropriate for interests such as life or personal good-being, which relates to the integrity of that person. These are interests that border on public policy and thus are possibly beyond the realm or domain of freedom of contract. So the true purpose of Article 5 then is to make it clear this point with respect, I'm sorry, I should have gone back to this one. The true purpose of Article 5 is to make sure, is to clarify this distinction, commercial interests and non-commercial interests. Non-commercial interests are outside the scope of the CISG. A similar policy decision can be found in another provision of the CISG. Article 2, sub A, provides that the CISG does not apply to consumer sales. And the purpose of this exclusion is to leave the issue of consumer law, which require different attention than commercial sales, to domestic law, leaving the matter to domestic law. Now, if that is the purpose of Article 5, then what happens to property damages? Let's test how the purpose of Article 5 works with respect to property damages. For example, what happens if a defective mechanical part that is delivered has caused damage to the assembled machine using that part? What happens? Under Article 5, the seller's liability for property damages is not excluded, so it is clear that the CISG applies. The question is it covered exclusively by the CISG, or is it a room for domestic law to be still applicable? Now, this slide is a little bit too detailed. I have an easier slide for you. Okay, there are divergent views on this point. One view holds that, and which is the majority view, holds that the CISG excludes all domestic claims, whether it's tort law, domestic products liability law with respect to property damages is excluded, and the CISG applies. Domestic products liability law as contract liability, this is also excluded by the CISG, and the same would apply for non-cumulative jurisdictions. This is the majority view, and which favors uniformity. It favors uniformity, which gives maximum unification. This is the majority view. The other view, the minority view, is that there is concurrence of claims, which allows concurrence of claims for property damages. CISG plus domestic law, CISG plus domestic law under the cumulative rule. If you take the non-cumulative rule, it's too bad. It's always a CISG that applies. But so these, and this is a minority view, and this view, instead of favoring uniformity, gives priority to domestic concerns over the protection of property or non-commercial interests. Now, what should we do with this? The basic concern that we have to address is to avoid overreaching by the CISG. Since the CISG is designed to balance the contractual or commercial interests of the seller and buyer, the protection of non-commercial interests or extra-contractual interests should not be exclusively dealt with by the CISG. And on the other hand, the countervailing consideration is that the balance of interest under the CISG. The CISG's design itself should not be overturned by allowing application of domestic remedies. So what shall we do? This is the view that the CISG Advisory Council has recently taken in an opinion that will be published sometime soon. The CISG Advisory Council has taken a middle ground approach, which depends on, well, which distinguishes the type of property damages. What type of damages that is being, what type of property that is being damaged. If a defect in the goods results in destruction or damages to the goods itself, the goods that is sold itself, the CISG should govern to the exclusion of any domestic remedies. This is because the buyer's remedial scheme under the CISG is designed exactly to deal with such situation. If concurrent domestic remedies are allowed, the purpose of Article 39, for example, the notice requirement, this cutoff period, the purpose of that provision is to expedite resolution of sales disputes. That purpose will be overturned by domestic law. So that should not happen. So if a defect in the goods results in the destruction or damage to the goods itself, it is the CISG exclusively that applies. The same applies to situations where the damage is caused to the property which in normal course of business or in course of normal use is expected to be used together with the goods that are sold. Let me take an example from a German case in 1998 in which there was a sale of live fish, and the live fish was contaminated by some virus. And the live fish that contains the virus was sold and was put together with the other live fish, which was the property of the buyer. And the whole pool of the fish were damaged. So that is a property damage claim, and that is the kind of example that I have in mind when I say it's damage to goods itself or to goods attached, combined, commingled, or processed in normal course of business or normal course of use. For these kind of property damages, it should be exclusively the CISG that governs, because this is the kind of interest that CISG intends to deal with. However, for other property damages, when damage to property other than those above are caused by the goods, the seller's liability are governed by the CISG, plus the domestic tort law, provided that the jurisdiction takes the cumulative rule approach. And this is because the existence of contract is only incidental in these cases. These property damage, the damage to the property other than those listed here, are incidental. I mean, contract, the existence of contract is incidental to the damage to these kind of, to these property. So that is the, and so for those damages, the CISG should not be allowed to bar domestic extra-contractual remedies. And that, I hope, will become the favored interpretation in the future of Article 5, because this is an interpretation that balances the need for uniformity while trying not to disrupt the domestic concerns for the protection of extra or non-commercial interests. And with that, I end my presentation. Thank you very much.
Finally, we have Professor Eiselen, who will talk about the integration of Electronic Communications Convention and the CISG.
Good afternoon, ladies and gentlemen, and I want to thank you at this stage for your perseverance and congratulate you on your stamina for still being here and alert at this time. There is compensation for this because I have decided to change my presentation from a highly theoretical one into a very practical one. And I've been able to do that by not changing anything myself. But thanks to a declaration that was deposited yesterday by the Dominican Republic with the Secretary General of the United States, and which means that the Electronic Communications Convention will come into operation on the 1st of March next year. So whatever I was going to say that was theoretical will become practical now as this will enter into operation. The change that has taken place in the last 30 years since the drafting of the CISG, the Vienna Sales Convention, due to the changes that have taken place in modern communications technology, has been breathtaking in many respects, and it has also changed the way in which business is done and in which business is carried out around the globe. No doubt also that the electronics revolution has caused and advanced the way in which business has become global today. Now, in legal circles, there, from the outset, was a lot of doubt about how the law would and could cope with these changes that were taking place. Was the law in a position to adequately cope with newer forms of communications? Now, when we look at the CISG at that time, 1980, when it was finally drafted and accepted, there is no indication of what we would today would regard as modern communications. The text of the CISG quite quaintly refers to telegram and telex, a form of communication from the 19th century and one from the 20th century, which in the 21st century are not used anymore. And the question has also arisen, well, what does that mean for the application of the CISG? The body that's been instrumental, first of all, in drafting the CISG, UNCITRAL, has had a huge success with the CISG, but it has also been proactive from a very early stage in regard to the new challenges posed by electronic communications, the internet, and we find that already in the 90s that they were busy with the drafting of new instruments. And this afternoon I will talk a little bit about some of these instruments, but I will specifically talk about the United Nations Convention for the use of electronic communications in international contracts. Now, that's rather mouthful of a title. I'm just going to refer either to the ECC as in my slides or the Electronic Communications Convention. We've heard something about the CISG Advisory Council. They were also proactive in that their very first opinion dealt with the impact of electronic communications for the CISG. Now, when we look at the CISG and electronic trade, Article 13 says that where writing is required, telegram and telex will be deemed to be writing, so that will be sufficient to constitute writing. It says nothing about email, SMS, or any of the other modern forms of telecommunications that we are using today. The other significant thing about formalities in the CISG is that there is no requirement in the CISG itself for any signature. The guiding principle for the CISG is the principle of freedom of form. Although Articles 12 and 96 makes provision for certain states to require writing, but writing only as a formality for the validity of international sales contract. So no state which is a member of the CISG may require signature as formality. But signature still remains relevant because the parties themselves, in terms of Article 6 of the CISG, may require signature as formality for the validity of their contract or any modifications of their contract. When we look at the various ancestral instruments that were devised to deal with electronic communications, we find, first of all, the Model Law on Electronic Commerce of 1996. Now, this is a soft law instrument that was devised to assist states to adopt legislation that would harmonize legislation around the world as far as electronic communications were concerned by drafting a model law. And that model law has also been very successful. It's been used in the legislation of about 50 countries around the world, including New Zealand law and South African law. Both of those countries adopted legislation in 2002 making use of the model law on electronic commerce. It was also a model law on electronic signatures, which has been less successful, and I will come to the reason for that a little bit later on. Then the convention, the ECC, or the Electronic Communications Convention, was adopted in 2005, 25 years after the adoption of the CISG, and I think it's also quite fitting that the Electronics Convention will come into operation exactly 25 years after the CISG came into operation. And then there's a very important document which is more of an informational nature, but contains very important research on specifically electronic signatures, and that is a document published in 2009. It's called Promoting Confidence in Electronic Commerce, Legal Issues on the International Use of Electronic Authentication and Signature Methods. That document explains the kind of difficulties that many countries have had with the adoption of legislation in regard to electronic signatures. Also explains the strategy followed by UNCITRAL in the Electronic Communications Convention. Now, when we look at the Electronic Communications Convention and compare that to the CISG, we find that the scope of application of these two conventions are virtually identical. They will apply, both of them, when the parties have their places of business in countries that have adopted these conventions in terms of Article 1 of both of those conventions, or where the conflicts rules leads to the law of electronic conventions country. What is very important in this, in the ECC, is Article 6, which deals with the location of the parties. One of the bogus sort of issues that were raised initially when people were discussing the problems created by electronic commerce was the issue of, well, this trade, these communications are taking place in the cyberspace. So how can you determine where the parties are or what the location of the parties are? Article 6 simply works with the physical place of business of the parties, especially in international sales. Someone is going to pay the price, someone is going to receive the money. Those are physical people, they don't live in cyberspace somewhere. So they all have a place of business, and that is the locating factor. in terms of where the parties are, where their communications are deemed to have taken place. And I regard this as a very important provision in the Electronics Convention. Writing doesn't really pose a big issue. It's been recognized from a very early moment on that electronic communications should also be regarded as writing and fulfilling any kind of writing requirement, provided that there is some permanence to it, meaning that it can be retrieved at a later stage. The Electronics Convention in Article 9 recognizes the validity of electronic communications as a form of writing, and that where writing is required, that an electronic communication will be sufficient. This position was also confirmed by the CISG Advisory Council in their opinion number 1. What has proved more troublesome is electronic signature. It has proved to be the greatest hurdle. Now, as far as the CISG is concerned, no country may require in its legislation that signature be a formality that must be required, that must be fulfilled for the validity of any agreement. But that doesn't, that's not the end of the story. The parties themselves may require signature as a formality, either for the contract to come into existence or for the modification of their contract. And that is a more troublesome situation, because electronic signatures is the one area where the draft legislation or the model law, the 2001 UNCITRAL model law, have proven not to be very successful due to partly technical difficulties and differences in the way in which this requirement could be applied. UNCITRAL in the Electronics Convention has followed a minimalist approach as far as an electronic signature is concerned. So it's not linked to any kind of technology. It simply says an electronic signature that parties can agree as to what will constitute an electronic signature between them, and that will also relate to a method of identifying the party and indicating the intention of the party as far as that mark or the signature is concerned, and that is sufficient having regard to the purpose for which that electronic signature was used. So it's in the hands of the parties themselves to determine what will be regarded as a valid electronic signature for their purposes. What is problematic, though, is that very often parties will use outdated standard terms that were created for the paper world, and that is then transposed in the electronic communication setting without taking proper notice of the kind of problems that this is going to cause, especially insofar as a signature requirement is concerned. You will find in very many of these standard terms that there's a non-variation clause insisting on writing and signature without the parties thinking about what kind of signature will be sufficient for the variation of the agreement. The CISG deals with non-variation clauses in Article 29. It says that non-variation clauses, a clause where the parties stipulate some kind of formality for the amendment or termination of the agreement, that such clauses will be enforced strictly. So you cannot change the contract without complying with those formalities. But then it goes on to create a rule which is similar to an estoppel, saying that where the other party has relied on conduct of a party where there was an informal amendment to the contract, then the contract can be regarded as amendment. So it's not as strict as it would be in some countries, like my own country, for instance, where these non-variation clauses are very strictly enforced. I think that traders internationally should consider removing needless formalities in their standard terms wherever they do occur, or make sure that they define exactly what kind of electronic signature should be sufficient to for the fulfillment of this requirement. An innovation in the Electronics Convention that you will not find in the 1996 model is that it makes specific provision for mistake that may occur in electronic communications. One of the issues that a lot of people felt uncomfortable with, because one can make a typo so easily in the electronic communications that you type an extra digit, and instead of ordering 10,000, now you order 100,000. And what happens in that type of situation? The two provisions of the ECC that is of particular importance here. First of all, Article 12 recognizes that where transactions take place by automated systems, whether that be two automated systems talking to each other or whether it's an interaction with a human being in an automated system, that such transactions are regarded as valid. But then in Article 14, it has a provision that where a human being interacts with an electronic agent and the human being makes a mistake in that interaction, then that party is entitled to change that mistake provided, and this is an important restriction on this particular right, that the communication with the electronic agent did not give the human being an opportunity to correct the mistake. Now the normal way that this would be is that you, when you have a transaction which is automated, the human being will go through a series of steps in which the various elements of the transaction are accepted or proposed. But right at the end, there should also be a summary of the whole transaction where the human being can assess, have I made any mistakes or not. Now where that last step is absent, Article 14 may come into play, provided then also that the human being notifies the other party as soon as possible about the mistake, and that that he or she has taken no material benefit from this transaction. The innocent party in this situation may, however, claim damages that has resulted as a cause of that mistake. So, for instance, if the party has started to produce goods and there is damages, then those damages may be claimed from the other party. My message this afternoon, I think I can summarize in 2 points. The first is, when one has regard to the provisions of the ECC, they fit in nicely with the CISG, and that is no surprise because this convention was drafted to augment the CISG, to update it in a certain sense as far as electronic communications are concerned. I believe that countries who are members of the CISG should seriously consider adopting the ECC as well. Although the CISG is very flexible and can deal with electronic communications, there are a few issues like mistake and the signature requirement which needs augmenting. Also updating Article 13 so that it is clear this deals and the CISG is sufficient in dealing with all kinds of electronic communications. So I believe it's important that countries should adopt this instrument, especially since it will now come into force. The second thing is that legal advisors should carefully consider the standard terms of all the clients as far as electronic communications are concerned, so that there are no unnecessary formal requirements like especially signature. The writing is fine, but the signature is a problem. Thank you very much.